So how much evidence do you need of domestic abuse to get help when you approach a service? Now, as with a lot of things within housing law, there is no simple answer, because the answer is there's actually different evidential thresholds depending on which service you're actually approaching. So I thought I'd do a little video. I'm going to look at the homeless application evidential threshold, then part 6, looking at also universal credit in terms of the local housing allowance, and I'll also talk about the MARAC and the DASH form as well, because I think that just might tie things together a little bit. And I guess to explain this coherently, we first need to actually look at what the definition of domestic abuse is, because the definition of domestic abuse as set out by the Domestic Abuse Act in 2021 basically is kind of known as this cross-departmental definition. So it applies to different departments of central government. So DWP and Ministry of Housing, Communities, Local Government is the ones we're caring about here in terms of homelessness and also universal credit. Now there are probably other areas as well which would be relevant, but we're going to just kind of focus on this for the time being. And if we first turn to the Homelessness Code of Guidance, so chapter 21 is all about domestic abuse, and early on in that chapter from 21.6 onwards it talks about the actual definition of domestic abuse. So I think it's probably worth just drawing a couple of things out from this. I'll bring it up on the screen because it's worth just reading the wording here. So 21.6 says that the 2021 Act, that's the Domestic Abuse Act, definition is set out below. For the purpose of the legal definition, A is referred to as the perpetrator and B is referred to as the victim. So notice here as well, it uses the word victim throughout rather than survivor. I know there's some debate around which word's better. I will sometimes use them interchangeably, but I'll generally use the word victim because it ties in with what the law is saying here. So 21.7, behaviour of the perpetrator, person A, towards another person B, the victim, is domestic abuse if the perpetrator and the victim are each aged 16 years or over and are personally connected to each other and the behaviour is abusive. So there's actually 3 criteria there. They've got to be over 16, they need to be personally connected, which we'll return to in a moment, and the behaviour itself needs to be abusive. So that's the kind of sets out our definition, and it obviously can go into a bit more detail, which I'll probably leave you to read rather than kind of go through it. So first of all, let's just kind of talk about what personally connected means. So if we actually just drop down to 21.9 for a second, essentially for it to be domestic abuse rather than non-domestic abuse, for want of a better word, the 2 people, or I guess it could involve more than 2 people, need to have some sort of relationship which is not just kind of being a neighbour or being strangers. So again, I'll kind of just paraphrase this rather than kind of reading it all out word for word. So effectively you need to have been either married or kind of engaged to be married, or in a civil partnership or engaged to be in a civil partnership, if that's the right word, or in some kind of intimate personal relationship, which it doesn't really define as far as I know, but I guess it's kind of all talking about close relations, sexual relations, that sort of thing. Or if at some time they've shared parental responsibility for a child, or their relatives. And I guess when it talks about relatives, we're talking about by both blood and through marriage, so potentially in-laws, that sort of thing could also certainly meet the definition of being personally connected. And then that third criteria that we talked about already is this kind of behaviour has to be abusive. And for me, there's some logical gaps within this. I'll explain that in a moment. So effectively, you've got these 5 overall areas, and there's also so-called honour-based domestic abuse as well, which kind of talks about further down in the chapter. But effectively, the behaviour is considered to be abusive if it consists of physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, or psychological, emotional, or other abuse. So some of those are quite complicated, but they are well defined. So for example, both controlling and coercive behaviour and economic abuse, whilst quite complicated, are quite well set out. So there's actually a criminal offence itself in terms of controlling or coercive behaviour. So because it might involve a conviction, it's kind of very, very technical about how it sets out the definition. So as I say, although it's complicated, it is set out. I would say particularly with the 5th one, psychological or emotional abuse, it becomes more problematic because there is a line somewhere between dysfunctional relationships which involve arguments and that sort of thing, and to where it actually becomes psychological or emotional abuse. And as far as I know, the Domestic Abuse Guidance Framework that comes with the Domestic Abuse Act itself basically doesn't really define that, or doesn't kind of go into it in detail. So I dug around quite a lot when this all came out and just tried to see if there is some kind of indication of when a dysfunctional relationship becomes abusive. And in effect, there was a few things I drew out. So for example, it seems that the behaviour needs to be intentional, so it needs to be done with the intention of harming the other person. So that's one thing I kind of drew out. Another thing was where effectively it becomes abusive where one person suffers psychological harm, if it's psychological abuse. And again, that doesn't kind of necessarily help particularly, but there is quite a lot of case law on when something becomes psychologically harmful, in the sense of damages claims, that sort of thing. We have historic sexual abuse claims, and actually part of the case and part of the compensation hinges on showing that the person has undergone some sort of psychological harm. So again, I'm kind of wish there was some more clarity on this. There is some stuff happening this year. So for example, in a couple of months' time, Legal Action Group, which is a really good publisher, is putting out a textbook on domestic abuse and the law, which I'm hoping will provide some clarity, but I don't know it will. I'll certainly be buying it, that's for sure. But as I say, we kind of got this potential gap and this potential complexity, and it is something I will return to later on. Not quite sure how yet, but I think it is something which is really important, because again, I would say, much of the abuse you're going to find that is domestic abuse will involve psychological, emotional or other abuse. So yeah, I think it's important to kind of understand more about it. I'm just not able to kind of explain much about it at this point in time. So this is the cross-departmental definition that we're working with here. And if we go to the best evidential threshold, I would argue, we go to the homeless application process itself. So that's part 7 of the Housing Act, and bear in mind this is the same across England, so every local authority would be subject to this. And about 6 months after the Domestic Abuse Act came in, the local government social care ombudsman, which may have been called the LGO back then, I can't remember when they changed their name, but they published a report looking at how it had gone so far. Obviously it was very early days. There were some risks that had been identified with the way the law was working, even before the Domestic Abuse Act came out. And I guess this was just kind of exploring how local authorities were doing in terms of enforcing it. And effectively, the answer is not terribly well in all cases. So on page 14 of the report, which is worth reading in full if you work in the sector, I'd say, because it gives you lots of kind of practical case examples and some really useful exploration of the subject. But page 14 I've quoted a lot, and if we read it first, local council's default position should be to believe people who disclose they've been abused. And it then goes on to reference the Homelessness Code of Guidance, particularly paragraph 21.24. And essentially in that paragraph it states in bold, in fact if we might as well go to that as well since we're here, that housing authorities should not have a blanket approach towards domestic abuse which requires corroborative or police evidence to be provided. Now that does not mean to say that local authority officers cannot ask to see if there is a crime reference number somewhere or if there has been a report made to the police. But just because there hasn't, that does not change the council's duties. As I say, the default position is to believe the person who reports they've been abused. And it gives some examples a bit further up this paragraph of reasons why there might not be that police or corroborative evidence. So for example, it says, in some cases corroborative evidence of abuse may not be available, for example, because there were no adult witnesses and or the applicant was too frightened or ashamed to report incidents to family, friends or the police. The housing officer may be the first person the victim is confided in. That's such an important point to make. There are so many times I've seen housing officers being the first person that the person goes to, because often the person wants practical help and it's the housing team that can offer that practical help. And yet that person gets failed again and again and again because the housing officer and the rest of their team do not take it seriously. I would introduce another potential reason why people won't report it to the police, and that is that some police officers are dreadful. Obviously not all of them. There are some really good teams out. In Bedford Borough we've got a really good team that specialises in domestic abuse cases and other kind of sexual abuse cases. They're awesome. But there are certainly some police officers who just are either really stupid or just kind of actually just downplay it and kind of just rather unpleasant about it. So that's one reason why you might not go to the police. Another reason is, even if you get a good police officer, a lot of the measures they can actually take are very, very modest. So, they might be able to get a domestic abuse, stalking and harassment order or something like that, which you think, okay, great, that's going to stop that perpetrator continuing the stalking and harassment. But those things only last limited periods of time, at which point you would imagine that the perpetrator is going to continue doing it if they haven't breached the order in the first place. There are certainly a lot of cases where things like non-molestation orders get breached a lot and the police just basically don't do anything. They don't kind of actually arrest the person or kind of take any further action against them. So that's, again, for those people who've been subject to domestic abuse for many years, that's a very good reason why they might not want to go to the police, and they might instead just want to go to housing because that is a route out of their situation into safe accommodation. So this shouldn't be too surprising in terms of this default position being to believe people, because if you look at most councils' adult safeguarding policies, and again they're locally written so the wording's always going to be different, but if I use Bedford as an example, the Bedford Borough Council adult safeguarding policy, which in fact covers all of Bedfordshire, basically states in bold and capitalised writing, if I remember correctly, that on hearing someone has reported abuse, the staff member must immediately refer those concerns to the adult safeguarding team. And basically the policy talks about having zero tolerance to abuse, as in if an officer hears that someone might be being abused, they have to do something. And it's kind of comes out of those Victoria Climbié type cases where dozens of professionals knew the abuse was happening and yet no one did anything. In Victoria Climbié's case, there were like 95 professionals involved in that child's case, and I think the only people who actually did anything was the taxi driver and a nurse. That was it. So 93 of those professionals basically failed to do anything. So that's kind of why we have such a low threshold on reports of abuse, and why we have to do something. Now, often they won't necessarily go that far when it goes to the adult safeguarding route for various reasons, which I'll tackle in another video. But basically, housing officers should be routinely making safeguarding alerts if someone tells them they're being abused. That's the threshold. It's a very low threshold. Now, if the council then made inquiries and they had a good reason to discount that person's report that they've been abused, then they would be entitled to say they're not satisfied the abuse is actually taking place. But bearing in mind, it will need to be credible evidence. So just because the perpetrator says they're not abusing someone does not mean they're not abusing someone. And I guess all this is really important, because within the homeless application process, if you went into a council, or if you contacted the council, you said, look, I'm experiencing domestic abuse, can you help me out with housing? You have almost certainly triggered Section 184 of the Housing Act and Section 188, which is the interim duty to accommodate in terms of providing emergency accommodation. So that would apply if there's reasons to believe that you might be homeless, might be eligible, might have a priority need. So assuming you're eligible or might be eligible, telling them that you're experiencing domestic abuse in itself would be reasons to believe that you might be homeless and also in priority need, because it's an automatic characteristic. And so the council should then place you or offer you suitable temporary accommodation whilst they undertake the inquiries, basically. So yeah, but in the absence of contravening evidence, the person should be believed, basically. That's the setting. So that's a pretty sensible threshold if we are serious about tackling domestic abuse. This is when it gets a bit less positive. If we look at some Part 6 policies, so I basically chose some at random around the country, and just to reiterate, Part 6 policies, the housing register policy itself, the housing allocation scheme is the technical term for it, they're set locally. So essentially councils can write their own policy as long as it kind of ticks a few boxes that central government set. So I looked at 3 councils, well I looked at 4 actually, but the first 3 actually had something useful to say about it. So Somerset, for example, it says that if the applicant is fleeing domestic abuse or other violence, evidence must be provided by an appropriate agency, such as the police, Multi-Agency Risk Assessment Conference, the MARIC, which I'll come back to, Multi-Agency Safeguarding Hub, which is I think is the adult safeguarding team, and Somerset Integrated Domestic Abuse Services, or Independent Domestic Violence Advisors. So you can see here that for Part 6, you would need evidence from one of these fairly kind of narrowly defined agencies. Now this gets very interesting, because ordinarily, if you approach under the usual default Part 6 process, but you tell them that you're experiencing domestic abuse, you should be dealt with as a homeless person and therefore dealt with under Part 7 anyway. And why council policies have so much detail on people who are at risk of domestic abuse and are not homeless is a little bit surprising. As I say, I'm not going to unpick it in this video, but certainly there's some big questions there about whether the policy itself is legal. But that's Somerset's policy. Central Bed similarly says supporting evidence will be sought from the police or other statutory bodies supporting the applicant. So again, that specifies it needs to be the police or other statutory bodies. Herefordshire similarly says the assessment will be based on verification by officers within the police or other agencies in conjunction with an assessment by the council's housing solutions team. And again, that potentially would open up the possibility of charities being referred to as well. I mentioned Southampton here as well because it only actually mentions domestic abuse once in the whole policy. So if you live in Southampton, you've got a pretty ropey housing allocation scheme and you should get on your council's back to improve that. But that's just something I noticed when I went through these. So I think most councils will probably have something similar, as in the Part 6 evidential threshold is going to be higher than the Part 7 threshold, even though there is this interesting relationship that if you approach under Part 6 but tell them you're experiencing domestic abuse, it should be default dealt with as a homeless application anyway. So as I say, I'm interested to hear if anyone's got any suggestions about that as to why that is the case, because it shouldn't be as far as I can tell. So that's Part 6. You've then got the universal credit evidential threshold, and this kicks in because ordinarily, if you're under the age of 35, you'll only get the shared accommodation rate in terms of the local housing allowance if you're in private rented accommodation. So you'll only get enough money in theory that would cover shared accommodation rather than self-contained. But there's a number of exemptions, one of which is where you have been victim of domestic abuse. I think it's specified since your 16th birthday. So at any point since your 16th birthday, if you have been subject to domestic abuse, you would be exempt from the shared accommodation rate and instead would be eligible for the 1-bed rate. And the universal credit threshold states that, and again I'll link to these different bits in the description. So paragraph 6 of this bit of guidance says that claimants will need written evidence from a person acting in an official capacity confirming that their circumstances are consistent with those of a person who has had domestic violence or abuse inflicted or threatened upon them. Again, I think if you look at the context, it's since their 16th birthday, And it goes on to specify that a person acting in an official capacity is either a healthcare professional, a police officer, a registered social worker, the claimant's employer, or any public, voluntary or charitable body which has had direct contact with the claimant in connection with domestic violence. And again, notice it's still using that term domestic violence. When you see the term domestic violence in any government document, it does mean that broader definition of abuse. It isn't just physical violence, just to make that point. I don't know why they still haven't changed the wording of it. You even still see this in the Code of Guidance for some reason. But again, we can see maybe a more reasonable evidential threshold here. But again, unless you've got that professional to confirm it, then universal credit, I would imagine in most cases, will just ignore you and basically just allow you to have the shared accommodation rate. Then finally, we've got this idea of the MARAC, and associated with the MARAC is the IDVA. And just to explain what those mean, the MARAC stands for Multi-Agency Risk Assessment Conference, and an IDVA is an independent domestic violence advisor. They're often kind of quite closely linked, because my understanding is, and I might be wrong about this, you won't get to be heard in MARAC unless you've got an IDVA, and probably vice versa, I don't know. So just to explain what the MARAC is, the MARAC is a multi-agency meeting which happens regularly. It'll be chaired by someone from the local authority. There will be professionals from the council's housing team in there, the homelessness team. There'll be people from probation, police, the IDVA team will be there as well. There might be social services, depending on who's kind of involved in that case, and there might be other people invited into it. And essentially what's supposed to happen is the IDVA is supposed to relay the wishes of the survivor, the victim, into that meeting, so that when they're assessing risk and when they're planning what is going to be done about that risk, in theory the survivor's wishes are taken into account. Now, I've seen multiple cases where the IDVA won't even ask the person's opinions about anything, or even won't tell the survivor that these meetings are actually happening. There's also issues around data breaches, because let's say, for example, you have a case where neither the perpetrator or the survivor are known to probation, as in there's no reason for probation to be involved, then probation should not be part of those discussions, and they shouldn't receive that special category data, because obviously most of this data will be special category, as in very sensitive. So probation should not have that data anywhere on their file. They've got no legitimate basis to have that on their file. And again, I dislike MARACs because certainly they can't be guaranteed to take into account the wishes of the applicant and to have that real-time discussion with them about what the options are, because actually to really kind of assess that and to work out what the survivor wants, the survivor's first going to need to know what the options are, and secondly we'll have then questions about those options, which then can kind of go back and forth, which is very difficult in that kind of MARAC system as it is. But in order to be heard at MARAC, you effectively need to hit a particular score on something called a DASH form, which I think stands for Domestic Abuse, Stalking and Harassment Assessment Form or something, words to that effect, which you can Google. And I guess if you're experiencing domestic abuse, it can be helpful, though certainly quite painful, to actually look at the kinds of questions that are asked here, because effectively there's like 24 questions ordinarily. There are some additional questions, I think, if it involves harassment and stalking. But basically the questions are all based on our best evidence and our best research on what leads to risk of domestic abuse increasing. So there might be some, what might seem like quite odd questions in there. So for example, question 19 says, has the abuser ever mistreated an animal or family pet? And the reason they're asking that is there is a correlation between people who harm animals and people who harm people, if that makes sense. So again, kind of some of the questions might seem a little, well, they're certainly all very sensitive questions, but they might seem a little bit odd. But that's the reason for them being those things, is that this is kind of a research-based exercise to establish what risk you're at. And effectively, if you tick more than 14 boxes, certainly I think that's what it is in Bedford. It might be different thresholds in different areas, because again, this is something which will vary locally. But certainly if you tick a certain number of yes boxes, then at some point you will basically guarantee to be heard at MARAC. And there is the possibility, if you were to score lower, that you could still get heard at MARAC because a professional basically thinks that there's still a serious risk. So bear in mind that logically some perpetrators will not score as high as others because they've never had a pet, or because they've never had children or something like that. So as you see, some of the questions are only going to apply to certain people. So again, if you're a professional using this, do bear in mind that if you've got a lower score, maybe you score like 6 or 8 or 10 or something, it's definitely certainly worth ringing up the team that deal with this to sort of say, look, I've still got concerns, they've only scored 6 or 8 or whatever, what do you suggest, and then kind of get their guidance on it. But I'd imagine that for, again, this is going to be pretty tough, I'm sure, to kind of, Google this and have a look through if you're experiencing it, but it kind of gives you an idea of kind of how it would be assessed. And as far as I know, you can self-refer. So if you're doing this yourself and you think it's true, if I'm ticking, 14 of these boxes, again, there should be contact details on there. as long as it's safe to do so, I'd suggest you ring up that team and basically just explain your concerns, because there's no way that they're going to turn away someone just because they've not been referred from a professional. Although I'm sure most referrals do come from professionals. So yeah, that's the dash form. That's what that kind of leads to that MAREC engagement. Now, whilst I'm critical of MARECs in general, there are some things they do very well, and one of which is first of all, they hold a lot of weight. So if a MAREC chair assesses the information they've got and they write a letter saying, yes, I think this person's at risk of domestic abuse in their home, then that's basically, kind of very strong evidence that the person is legally homeless and therefore automatically in priority need. So yeah, and as we've seen already, evidence from the MAREC is basically always going to take to be enough evidence in terms of those Part 6 and that DWP, the universal credit thresholds. So they're certainly worth having. And in those MARECs as well, they'll be talking about other potential options in terms of things like non-molestation orders, the other kind of court orders that might reduce the risk that someone's at. Now, since I mentioned court orders, the Homelessness Code of Guidance does mention that people should not be expected to stay put just because there is a non-molestation order in place, because it's recognised they're quite weak orders in one sense. It's very possible for the perpetrator to breach them multiple times, and as I say, they won't always get arrested for it. So just because you've got a non-molestation order in place does not mean you're not homeless. If you wish to approach your council for housing assistance under the Housing Act, then the fact there's non-molestation orders in place will be helpful to evidence the abuse that's happened, but it won't be something which the council can say, oh, you can stay put, you're safe, there's a non-molestation order. So just bear that in mind as well. But other than that, hopefully there is some information in there which is useful. I guess I'll probably finish by saying I've had some really, really good experiences of charities that support domestic abuse survivors. Probably as competent as any charities I've come across. I'm fairly critical of charities in general, but certainly domestic abuse charities I've come into contact with, they appear to be getting high caliber people involved, and they are committed to reducing risk and kind of working with people. So they often go a lot further than other professionals will do, other charities will do, and they tend to be more willing to challenge local authority decisions and so on. So that's not to say that they're always perfect. And when it comes to IDVAs as well, generally I've had a really good experience of IDVAs. Certainly the ones in Bedford have been great. I have had experience of an IDVA once where they just basically shrugged that the person was not getting the help they should be getting. I might do a video about that at some point. But yeah, but other than that, generally they're good. They're good people in my experience. They're actually well trained. There is actually a qualification associated with the role, which is quite nice. And as I say, they tend to genuinely care. So they're good people. So I guess I'll say in regards to that if you're experiencing anything like this, then it's certainly worth a call to a specialist charity or an IDVA service, just to kind of explain stuff. I'd be confident you'd be heard out, and you get some good suggestions, some good advice, and potentially a lot more in terms of what support they can offer. So I'm hoping that's all helpful. I would say that if you're in that sort of situation, it's probably worth going to a charity or specialist service or an IDVA service before you make a homeless application. Now, I don't rule out making a homeless application at all, first, but I think that although the law is very good around Part 7 in the homeless application process and that evidential threshold, there are still plenty of housing officers out there who will literally say, no, there's no crime reference number, that's it, that's the end of it. So having that professional involved in you, if you've been to a specialist charity or if you've been to an IDVA service, they will almost certainly help you in that situation to make that smoother for you and to try and make the council actually follow the law. And if you're a professional who is interested in this sort of stuff, as I'm kind of saying more and more these days, we do online training. We don't cover this stuff in as much detail as I've covered in the video, but we do talk about homeless applications and how domestic abuse relates to it, and again, kind of some of the pitfalls you're going to get through the process. So we do like one a month online, roughly one a month. So check out Eventbrite in the description if you want to find out more. It's very reasonably priced. £60 if you're attending in a professional capacity, and £30 if you're paying for it your own back and coming in your own time. And it just provides that framework of understanding, okay, there are lots of other detailed bits of the law which there isn't enough time to cover, but it gives you that framework of how the system works, how the process works, how to make a homeless application the best possible way, how important it is to do it the right way, and things like priority need and intentional homelessness. Some of the case studies we discuss involve quite a lot of domestic abuse, so this is very much something which we focus on during the day. And if you've got any questions about this in general, just stick it in the comments anonymously. I take it anonymously to the next live stream. We do it every Thursday night, 7:30 PM. It's recorded, so you don't have to watch it live. But that just gives us time, so when I say us, I mean myself and my colleague Shannon, and then Will and Karis from Virgo Solicitors, to unpick cases in a bit more detail. And we've also done other videos on the channel which kind of look at things very relevant to this. So if you go back through the video section, for example, there's a really good event we did called Trauma, Homelessness and Priority Need, which certainly kind of covers things which are going to be relevant to domestic abuse. And there's another event called the Ethics of Gatekeeping, which again kind of helps you understand why the system doesn't work and how you can make the system work if you're up for it.